Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time, maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case would be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
C-A-R-T-H-O-N, recall from this morning. We have an agreement resolving her case. I'm approaching with an agreement score sheet. Got any, Ron?
Yes, sir. Thank you.
Thank you. And I do need to provide probation a copy, Your Honor. I apologize. So, this is Ms. Carthon. Let me take that extra copy for you. Under the terms of the agreement, in 21 CF 2665, which is a VOP case, and 23 CF 905, Ms. Carthon will be changing her not guilty plea in 23 CF 905 to nolo contendere. She'll be admitting to VOP. There will be a withhold adjudication as charged. And so she's not becoming a convicted felon. There was a previous withhold in 21 CF 2665, so she'll be maintaining that withhold. Reinstate and modify on count 1 of 21 CF 2665, which is the felony count. As to felonies, which means the felony VOP and 21 CF 2665, and also the felony battery charge in the new law case. There will be a new concurrent term of 12 months community control, followed by a new concurrent term of 12 months drug offender probation. She'll have to do the anger management class. She'll have to complete her existing obligations from 21 CF 2665, and that, as my understanding, includes, but is not limited to, substance abuse evaluation and treatment was already part of that case, the first case, and that'll continue to be part of the reinstated and modified arrangement. $100 VOP fee, $967 court costs, $250 PD fees. As to misdemeanors, which are counts 2 and 3 of 21 CF 2665, it's stipulated that probation has already expired as to those misdemeanor VOPs. That was a concurrent 1129 probation, and that's run out.
Very good. State?
That's state's agreement, Your Honor.
Ms. Carthon, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and you're okay with the score sheet?
Yes, Your Honor.
And the terms of the plea agreement are contained in your written plea agreement that you signed. So have you read this closely?
Yes, sir.
And did you go over it in detail with your attorney? Make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this plea agreement, this will be a final adjudication of your case. You'll be waiving the right to go to a trial, as a matter of fact. That's an invaluable right. You're comfortable waiving that? You believe this is in your best interest to go this route for a
Yes, sir.
plea agreement?
Yes, sir.
Okay, and you're entering this freely and voluntarily? Nobody coercing you?
Yes, sir.
Okay, do you have any further questions regarding this?
No, sir.
Okay, very good. Did I ask the state if it states an agreement?
I'm not sure you did, Your Honor.
If you didn't, Your Honor, this is a state's agreement.
Okay, very good. And so based upon that testimony, the court will accept the plea agreement. There'll be an admission of the violations of probation. The 2 misdemeanor VOPs have expired, so we're really just dealing with count 1 in 2665 and then the felony battery in 905. So the court will continue to withhold adjudication, reinstate and modify as to count 1 of 21 CF 2665, that's the felony VOP. And there'll be concurrent terms of 12 months community control, followed by a new concurrent term of 12 months drug offender probation. So both the felony probations will be identical, but they'll run together. So it's a total of 12 months community control, followed by another 12 months drug offender. Is that your understanding?
Yes, sir.
Okay. In addition, as a condition of the probation, you got to take the anger management class, complete any other existing obligations under the prior probation, and then the fees and costs as well. So, any questions?
No, sir.
Okay, thank you very much.
Your Honor, she does need to report today.
Okay.
She's trying to rush out to get to work in time too, but you do need to speak with this young lady about where to go, okay? Mr. Officer Johnson. Okay, thank you.
Thank you.
Thank you, Your Honor. I'm ready to go with my other out-of-custody plea,
Okay.
Your Honor. If I could call Patrick Doherty. Your Honor, Mr. Patrick Kent Doherty is before the court, recalled from this morning in 22 CF 2969 and 22 CF 2970. These are two new law cases. May I approach with the agreement that's been worked out?
You may.
As I do that, I wanted to note, Your Honor, that the state is going to be amending the score sheet. One of the cases is being dismissed under this agreement, and one of the counts in the other case is being reduced. So the state and I've been over it with the defendant. There will be a reduction in the score.
Okay. Very
May I
good.
approach?
You may. Thank you.
Thank you. I believe everybody signed it, Your Honor. I apologize. Could you
I'll
make
look
sure?
at it.
Thank you.
Yep. Everybody got it.
Your Honor,
Everybody
under
signed.
the terms of the agreement, the state is agreeing to dismiss 22 CF 2969 in exchange for the following: adjudication of guilt to lesser included offense, possession of controlled substance, and that's on count 1 in 22 CF 2970. Madam Clerk, I did not write the case number for possession of controlled substance. Is that necessary?
The statutory citation, you mean?
Right, I didn't write the statutory citation for lesser included possession of controlled substance. Do I need to do that?
It's 893-1368.
Yeah, thank you. I'm sorry, Your Honor,
That's all right.
I tried to do that, but I forgot it. This was drafted a number of months back. So. And there will also be adjudication of guilt to counts 2 through 4 as charged in 22 CF 2970. It will be 3 years concurrent standard probation on counts 1 through 3 with a special condition. We were very intentional about this language, Your Honor. He's been out on bail for a long time. He works with his dad who relies on him, so the state has agreed with strict language here that he'll be allowed to do street to bed, enter and successfully complete Phoenix House. The defendant shall attend as soon as a bed becomes available and report for transport at such date as indicated by state probation. So it's anticipated that as soon as Phoenix House gets a bed, that probation will advise Mr. Doherty that he has to appear at the Okaloosa County Jail for the transport vehicle of Phoenix House. And so he'll have to maintain strict contact with his POs so they'll know how to reach him and advise him of that. And his obligation to be reporting as soon as they say.
Very good.
And continuing, Your Honor, time served on the misdemeanor count in 22 CF 2970, which is count 4, 615 court costs, 150 PD fees, no drugs, no firearms during supervision, of course, random UAs at least once a month.
Very good. State?
That is the state's agreement, Your Honor.
Okay, Mr. Doherty, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement, and those same terms are written in the written plea agreement, which you have signed. So, first question, did you read this closely, the plea agreement?
Yes, sir.
And did you go over it in detail with your attorney, just to make sure you had all your legal questions answered?
Yes, sir.
And you understand that by entering this, you're waiving the right to go to a trial, and this will be a final adjudication of your case.
Yes, sir.
And you believe that this is in your best interest to enter into this plea?
Yes, sir.
Okay, nobody threatened or coerced you to get you to enter into this?
No, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. What did you say about you're going to provide the score sheet later?
Yes, Your Honor.
Okay.
I believe he'll score, it is going to be downward departure, Your Honor. I do believe his lowest permissible sentence is going to be 19.2 months. With the score sheet.
What was the associated score that's less than the 58 that was listed? You know what 19 relates to, 1994? That's okay.
So the downward departure is based upon a uncoerced negotiation?
Yes, Your Honor.
Okay. Very good. Okay. So based upon that, the court will accept the plea agreement. There'll be an adjudication of guilt on the lesser included charge of possession of a controlled substance, which is count 1, 22 CF 2970, and counts 2 through 4 as charged. The court will sentence the defendant to 3 years concurrent probation on counts 1 through 3 on 2970, with a special condition of street to bed, enter and successfully complete Phoenix House, which is a substance abuse program, which we all know. Defendant shall attend as soon as a bed becomes available and report for transport at such date as indicated by state probation. So you'll also, on the misdemeanor possession of paraphernalia, you'll receive credit for time served, and that'll be completed. And you've got your standard court costs and fees, and the standard no drugs, firearms during supervision, UAs, etc. Okay, any question?
No, sir.
Okay, good luck with your Phoenix.
Sierra, thanks for
Hold on just a second.
Judge, this is Sierra Banks, number
Hold on just a
54.
second. Okay. Mr. Harper, sorry, go ahead.
Judge, this is Sierra Banks. She's before the court on 19 CF 1454, 19 CF 1459, 21 CF 454, 22 CF 2784, and 23 CF 1170. Judge, we've been asked to move this to a miscellaneous date in November. At issue here is with respect to one of the cases, the victim in this matter needs to be contacted so that the state complies with Marcy's law. I think we're in negotiations for a possible plea. That case is the holdup at this particular point, but we anticipate a plea in November.
Okay. So court will continue this until November 21st in the morning.
Mr. Bonilla?
Okay, let me. One of the cases that was on this morning's hearing, Jamal Carter,
Yes, sir.
is that yours?
Yes, sir.
We have in our notes, or actually the clerk has in her notes from the last hearing, that there was going to be a plea entered in abstention, but she doesn't show any having been
I have
filed.
it with me, Judge.
Okay, so it will be a plea. So you just haven't filed it yet?
I have it with me, and I was going to give it to the court, to give it to the clerk.
Okay. Okay, don't forget to give it.
I know.
Just want to make sure
Haven't
we're,
been called yet, so we're just.
Okay. very good. Okay. I'm sorry.
Bonilla.
He's number 58 on the docket, Judge.
Yes, sir, go ahead.
He's before the court on 22 CF 1558. We had moved him here today for a bond hearing. I noticed it in the filed bond motion last week. Essentially, to simplify what occurred, Judge, he was out on bond. He got a misdemeanor construction without a license charge, which is still open and pending. That in turn violated the terms and conditions of his pretrial release. His bond was revoked at first appearance. He's here before the court today to ask for the court to reinstate that bond and allow him to continue hopefully working on the outside so that he can fight this charge on the outside, Judge.
State?
And, Your Honor, the victim and the state do object to his bond being reduced. Obviously, the charge that he has with Mr. Harper is a very serious matter, and then he went out and got a couple of misdemeanor charges, Your Honor, so.
So what were the misdemeanor charges? I heard one. Was there more than one?
Your Honor, I have I have a worthless check that I see open, and also a contracting without a license that I see open, Your Honor.
Were those separate separate cases?
Yes, Your Honor. I received their certification.
I apologize, Judge. I wasn't aware of the worthless check. I was aware of the fraud, the license, construction without license, Judge. What, if I can, I don't know if the state is finishing their argument.
Just that, Your Honor, again, this case that Mr. Harper represents now is extremely serious, and I think that, it does, implicate the safety of the community for him to be out on bond, and then also, even committing even new misdemeanor charges, I am concerned about his ability to follow the laws, Your Honor.
What was the original bond that was set on 1558 that was revoked?
Judge, that was 50,000 cash confession. If I
Go
may,
ahead, Mr.
Judge,
Hope.
the allegations with respect to Mr. Bonilla, a worthless check, possibly, the conduction of construction without a license, both of which are financial crimes, neither of which are violence, but for those cases, and the charge that he's presently charged with in front of this court, he has no prior record. With respect to this charge, the victim in this matter is in Texas, resides there. He is certainly no threat to her. If the court is inclined to have concerns with respect to Mr. Bonilla out of custody, certainly he would remain within the state of Florida and submit to a GPS monitor at the lowest permissible date if the court permits and believes that that's pertinent. But again, these misdemeanor cases which are pending were just financial in nature, Judge.
What was the, what is the status of the underlying case?
Judge,
We're
on the underlying
over a
case,
year old.
Yes, sir.
Where are we at?
we had some difficulty locating the victim because she's, her immigration status is kind of up in the air. The state located and provided us recently with her address in Texas. We're going to schedule to do her depositions before the next court date, and then hopefully we should be ready to proceed to trial, either plea or trial next cycle.
Okay. Well, I would certainly be more inclined to reinstate if there was a single situation, but there's been two separate new law violations. So based upon that, the court's going to deny the bond, but hopefully we'll get some resolution here relatively soon. The next court date is December 13th, pre-trial.
Thank you, Judge. Michael Costin is next, 61 on the docket, Judge. He is before the court on 23 CF 1401, 23 CF 1402. The state and I are close to a resolution in this case. The outstanding issue is the victim in the vehicle theft, whether or not she's agreeable to my counteroffer. If the court would permit me to leave this for Thursday for a plea, I think we could resolve it this week. This
Okay.
was set for plea or continue, and this is the first time up, Judge.
We'll continue it until this Thursday.
Thank you, sir. This Thursday, she just needs to talk to the Thursday. Yes, sir.
James?
This is another case, Judge. This is Alan James, 23 CF 836. The victim in this matter, I've emailed Ms. Sandler about a possible resolution. We're basically about 3 months away from where our counteroffer is and their offer. If we can leave this for Thursday, if the court will permit me to do this, I think it's very probable that we can come to a plea. They just need to confirm that the victim in this matter is agreeable to my counteroffer.
Okay. Okay, we'll continue this until 10/16. But I just want you to know, we don't want to make jury review become just another status where we're dealing with these. But I'm trying to kind of balance. Some of them we want to get them done with, and I understand that. But just remember that. Go ahead.
I have one more to put on that day if the court will permit me, but that'll be it. And going forward, I won't do that.
Okay, but just try, if we can try and get them. I say, if we need it for that day, it's fine. I don't think there's going to be a heavy docket that day, but.
Dustin Jennings?
Judge, this is Dustin Jennings before the court on 22 CF 2957, 22 CF 2958, and 23 CF 1437. Judge, this would have been a plea today, but I think there's some issues with respect to his score sheet. I don't think that it's correctly tabulated. He should have no prior record. It reflects an actually not so good record. I've spoken with Sandler. She's going to do some research. While she was in court, she verified that there were some issues with that. If we can leave this for this Thursday, we will get it worked out. Mr. Jennings will be entering the plea on that date.
Very good. Continue to 10/16,
So,
Thursday.
9 a.m.
Yeah, you're right. No, we talked about that. Judge, this is Renwick Keel. He's before the court on 22 CF 464, 22 CF 2026. Mr. Keel is represented by Mr. Gates on 22 CF 2026. If I may just have a moment so he can sign the document.
2076 is Mr. Gates, I believe. What's your case number, Mr. Gates?
23C of 2026.
2026?
Yes,
Oh, my goodness.
There are seven
Yeah, I know. The clerk made a mistake, that's the first. Hold on.
It is 7-6.
I wrote what Mr. Harper wrote down. And it's-
Oh, you're throwing Mr. Harper under the bus?
I got it.
Oh, okay.
I'm,
So is it 7/6?
It is
So the
7-6.
clerk is not making a mistake. Well,
No, you're
that
not.
makes more sense.
I made a mistake. It's my fault. I should have got that. I did that.
That's the worst thing that happens today, Mr. Gates. You'll have had a heck of a good day.
Well, I forgot the files first off, and then I walked away when my car door opened. So this is kind of the middle of the game right now.
Judge, Mr. Keel is before the court on 22 CF 464 and 22 CF 2076. The adjudication of guilt, be withdrawing his plea and entering a plea of no contest. In 22 CF 464, he'll be sentenced to 20 months Department of Corrections with credit for all time served. This sentence will be concurrent and coterminous with 22 CF 2076. He'll be assessed $515 in court costs, $150 cost of defense, reserve restitution to Eglin Federal Credit Union. In 22 CF 2076, Be 20 months, Department of Corrections with credit for all time served. The sentence will be concurrent and coterminous with 22 CF 464 court costs. Restitution of target in the amount of $366.33. He is asking for 24 months to pay the costs before they're sent to the lien. No action on the FTAs. And Judge, this will be a stipulated downward departure as part of a negotiated plea agreement between the parties. And I believe the state will be filing a score sheet later. You may approach, Judge.
You may.
And I'll just say ditto.
Okay.
Ditto. Same.
Okay, Mr. Keel, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
And the state is in agreement with this?
Yes, Your Honor, and this is a downward departure based on a legitimate and forced plea bargain. Mr. Keel's most permissible sentence is 28.28 months.
Okay. Did I swear you in, Mr. Keel?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I was just looking it over, and the written plea agreement, which you've also signed. And first question is, did you read your plea agreement closely? Did you read this thing closely?
I sure did.
And did you go over it in detail with your attorney? I'm sure you did, but I got to ask you these questions on the record,
Yes, I did.
just so you make sure that it's uncoerced and free and voluntary. So you understand that by entering this plea agreement, I'm sure you do, but I got to ask you, you understand you're waiving some valuable legal rights, the right to go to a trial and to fight this thing?
Yes.
And you've got some good lawyers. I think you already won one case. You got good lawyers. You believe this is in your best interest to enter into this plea agreement rather than going to trial on these cases?
Yes.
Okay. And you have had all your legal questions answered, not only by Mr. Harper on your one case, but the other case that Mr. Gates is handling for you. You had the opportunity to ask any question, legal questions you need to.
I have. I'm satisfied.
You're satisfied. You understand what's going on.
Yes, I do.
And you believe that this is in your best interest to enter into this plea?
It is.
Nobody threatened or coerced you to get you to enter into this, did they?
I stepped on my toe one time. No, but all jokes aside, no, I'm good.
Don't joke.
We get X-ray, make sure he's getting a broken arm, Joe.
That's right. Let the record reflect. And it's one thing they tell us, Mr. Keel, they say that the jokes that appear funny in open court don't look funny when they're being transcribed. That's just yeah. So, anyway, so the court will accept your plea, and there'll be an adjudication of guilt on both cases. In case number 22 CF 464, you're sentenced to 20 months, Department of Corrections. You will get credit for all time served. And this sentence will be concurrent and coterminous with 22 CF 2076. Okay, so in both cases, you're getting 20 months DOC with credit for time served on both, but they'll be served at the same time, and coterminous. So you also have fees and costs. In both of these cases, there will be in one case, the restitution is reserved in the 464 case. The other one to target, the restitution amount has been established, and it's $366.33. And you'll have 24 months from the date of release to pay for the restitution and or the court costs before they go to collections. You will have no probation to follow, and you'll have no action taken on any failures to appear that might be on your record here. Question?
No.
Okay. Thank you very much. I'm sorry. Yes, sir. You do have, even though We just announced the plea and the agreement and the sentencing. You do have 30 days to appeal it. Okay? Thank you.
Michael Rogers?
Judge, this is Michael Rogers. He's before the court on 22 CF 3127 and 23 CF 1828. Judge, at this time, he's going to withdraw his previously entered plea and enter a plea of no contest and admit the violations of probation, the adjudication of guilt.
Are both of these VOPs?
No, Your Honor, one's a new law charge.
Okay. Go ahead, I'm sorry.
Is it not reflected that way on the docket? Or?
Yeah, it does. That's why when you said VOPs, it threw me for a second.
Adjudication of guilt, 9 months in the Okaloosa County Jail to run concurrent, credit for all time served. There is a second-degree misdemeanor that will be given credit for time served. Revoke and terminates prior supervision. Assess all applicable court costs. He's asking for the costs to be reduced down to judgment. My understanding is that the state will be filing a score sheet later. This is not a downward departure, Judge.
Okay.
Am I correct?
You may. State? State?
That was
Wake up.
Ms. Sandler. That was Noah's case.
Oh, Michael Rogers.
Rogers, are you in agreement with this plea agreement?
Yes, I am.
Okay, very good. So, Mr. Rogers, would you please raise your right hand? And let me swear you, I got to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
Okay. So I just need to ask you a few questions. One, to make sure you understand what you're doing, and make sure it's free and voluntary. That's why I'm asking you these questions. So, first of all, you heard your attorney state out in detail the terms of the plea agreement, and I see those terms are in writing on the written plea agreement that you've signed.
Yes, sir.
So my first question, did you read this, your plea agreement?
Yes,
You
sir.
read it? And did you go over it in detail with your attorney? There's a lot of legal stuff in there as well. Did you read it and kind of just make sure you had all your legal questions answered about this plea agreement?
Yes, Your Honor, I believe we did.
Okay. And you're comfortable, you understand what you're entering into today?
Yes, sir.
Importantly, you're waiving some valuable legal rights by entering into this plea. The right to go to a trial and to force the state to prove their case beyond a reasonable doubt, confront witnesses. You're putting that aside and saying, no, I'm going to waive that so we can have a final resolution here today.
Yes, sir.
Is that what you want to do? You believe that's in your best interest to do it that way?
Yes, Your Honor.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement. And I'm just trying to read this and
Sorry,
trying to.
my handwriting is atrocious, Judge. There is a
So the 9 months county jail is concurrent, basically the 2 felony charges?
It's the 2 felony charges as well as the misdemeanor charges that were first-degree misdemeanors. There is 1 second-degree misdemeanor,
Right.
which is just time served.
Okay, very good. So you have basically a total of 5 charges. And as your attorney said, you got 2 of them are felonies, 2 of them are first-degree misdemeanors. That's upward. You could have gotten a sentence up to a year, but I can't go over that. And then you've got a lesser charge that's less than a year. So for your 2 felonies and your 2 first-degree misdemeanors, you're going to be sentenced to 9 months in the Okaloosa County Jail, concurrent. So there's 9, 9, 9. They're all served at the same time, okay? And you will get credit for time served on each of those. They'll be calculated a little differently for each one. You'll get credit for time served for all of those, okay? And with regards to the other misdemeanor, that's credit for time served. You're done with that, okay? In addition, you will be able to have all of your court costs and fees reduced to a judgment. Are we going to reduce to a judgment now, or do we give him a little time after he gets out in order to do that? I don't know.
Judge, that's fine. He'll talk to the court after he's done if he needs some time to open that up or pay that off at a payment plan, because he's.
So
he's gonna have to
right
do
now,
something.
it's under this agreement, and what's being sent us today is all the fees and costs will go to a lien, right now.
Okay.
Okay? Any questions?
Yes, sir, Your Honor.
I just have a matter.
Yes, sir. Judge, this is Jonathan Wallace. He is number 70 on the docket, 23 CF 1219. Judge, this was noticed and set for a bond hearing. Basically, what happened is that his case was transferred from Judge Brown's division to this division. Contemporaneous with that transfer, he had a changeover in attorneys from Mr. McKinney at the Public Defender's Office to my office. There's some evidence within Benchmark to substantiate that he never received notice because it came back as undeliverable. I noted that in my bond motion, but his contention is that he wasn't aware of his court dates, and due to the confusion and the changeover of local counsel, as well as the visions of the court, he didn't intentionally or willfully skip his court date. In fact, he thought his court date was still pending by the time that he was arrested.
Okay. Can I speak?
What are you going to say? Yeah.
And then it got switched to 80.
Sure. I had that in my motion, Judge. He had correspondence from his previous counsel saying that he had court on a specific date. Subsequent to that, counsel got changed over, judges got changed over, and so that date was no longer applicable. He wasn't aware that he had a new court date in front of this court that was different from what he was previously told.
What's the state's position on this?
Jonathan Wallace.
It's 23 CF 1219.
I'm sorry, Judge, I'm not seeing him on the docket.
Well, I think he may have gotten, for some reason, pulled off the dock, 'cause I have mine X'd out.
I showed that this bond hearing paperwork was filed Friday, when I had already sent out the updated document.
Yeah, well, that's all right.
Well, I have him on my docket.
Okay.
Well, we'll do it, but it's 23 CF 1219.
This is getting this.
Okay.
It's mine, sir.
His first name is Jonathan. Last name is Wallace. Charles.
Your Honor, the state is not going to object to this motion to reinstate the bond. Your Honor, it does appear that this did get transferred over, and I apologize to the court, this is a new case to me. Did get transferred over from Judge Brown. It then became, I think, either Mr.
Okay, well, that's fine. As long as it's say, just, we want to know. Based upon that, the court will grant the motion to reinstate the bond.
Thank you, Judge. And procedurally, I think that the jail categorizes this failure to appear as different or separate from this offense, and we would be asking for a signature bond or an ROR as to a failure to appear associated with this charge, Judge. If the state's okay.
I'll do an ROR.
Thank you, Judge.
Thank you.
All right, when you get out, come see me. And for 12/11 should be his
Yes.
court date.
Yeah, the next one. Be 11th of December.
Thank you, sir. Judge, that's all I have this afternoon. Thank you, Judge.
You have a nice day.
Your Honor, the case on behalf of Mr. Devontae Hill. He's before the court in 21 CF 568.
I don't have this one on my docket. What's the,
Last name is Hill, Hill. First name is Devontae, Devonshae. Case number is 21 CF 568.
sorry, well, give me the date, give me the number again.
21 CF 568.
Okay, go ahead.
Yes, Your Honor, I'm going to have Mr. Hill sign the plea agreement. He'll be admitting the violation before the court, Your Honor. May I approach, Your Honor?
You may.
State will be filing this court sheet later.
Thank you. Would you please announce the agreement?
Yes, Your Honor. Mr. Hill will be admitting the violations before the court. If I can approach Madam Clerk, so she can follow along with this, Your Honor. Mr. Hill will be admitting the violation before the court. He was previously adjudicated guilty. We're going to revoke and terminate his outstanding probation. Sentenced to 24.475 months Department of Corrections with credit for all time served. In addition, the state's agreed to credit from January 25th, 2023 to September 21st, 2023, a total of 240 days credit. Mr. Hill had written a letter requesting transport on the January date and finally got transported on September the 22nd. The state will be, has agreed to this being a concurrent and coterminous sentence to his other DOC sentence. He received in 5/1/2020 CF 462, that's a Pasco County case. $100 cost of prosecution, $150 defender fee. Mr. Hill would ask for 24 months from the date of release to pay those costs before they're sent to collections.
State.
Case agreement.
Very good. Mr. Hill, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in your written plea agreement that you've signed. My first question, did you read this closely?
Yes, sir.
Did you go over it in detail with your attorney, make sure you understand all the legal issues that are contained in here, and you have all your legal questions answered?
I just don't understand that coterminous.
Yes, Your Honor, as I explained to Mr. Hill, it essentially means it ends at the same time as his other sentence.
That's correct. So it brings them together at the same time.
Like the Pasco case?
So both those cases will end.
And I can, just so the court's aware, I can explain, because what Mr. Hill is having issue with is he's already served that DOC sentence.
Right.
So he's already EOS'd on that. And essentially, the state's position was that they wanted the 24 months concurrent and coterminous, and they would let DOC calculate all that. They wanted him just to get the DOC, let them calculate it, And then if he was EOS, he'd be EOS. If not, he would have to finish whatever that balance was. They did not want to agree to stipulate to the credit served today, is what I was told.
Does that make sense?
Yes, sir.
Okay. Yeah, one of the things a lot of people don't understand is the actual calculation, credit for time served, that's one thing. Every time we have one of these deals, the one question every defendant asks is, will I get credit for time served? Okay? That's important, obviously, okay? But that's actually not determined by the court. That's determined usually by the jail. They're the ones that are so we put it down, we kind of set the framework, and then they actually do the calculation. So that's why you have to sometimes have this kind of language like that, so that it'll make sense to the jailers. So, so with that question, any other legal questions that you have?
No, sir.
Okay, and you believe that this is a fair resolution of your case?
Yes, sir.
Okay, you understand that you're waiving the right to go to a trial. This will be a final adjudication.
Yes, sir.
Okay. Very good. Based upon that, court will accept this plea agreement. You were previously adjudicated guilty. The court will revoke and terminate probation and sentence you to 24.47 months DOC with credit for all time served. And the state has agreed to a specific credit from January 25th, 23 to September 21st, 23 for a total of 240 days credit. Also, the sentence will be concurrent and coterminous. Concurrent means runs at the same time. And coterminous, which means it ends at the same time, with 512020 CF 402. That's the Pasco County case, which the defendant has already sentenced to DOC. So you've got a couple of fees and costs, and you'll have 24 months from your release to pay those court costs, and then it'll go to collections. Okay? Any questions?
No, sir.
Okay. Sir, you do have a right to appeal this, even though we just sentenced you. You got 30 days to do this.
All I ask for the court, Your Honor, if I may be excused.
You may.
Thank you, Your Honor.
Have a nice day.
So I'm trying to find my cheat sheet. Will the court bear with me just a moment?
Take your time.
Okay. I found it.
Okay, good.
Under Steve Medina with Tommy L. Averett. Mr. Averett is docket 7823 CF 1452. And Your Honor, he's signing an agreement that we've worked out with the state. Unfortunately, man, I don't have a copy for probation. Yes. That's fine, 1016. I got to do that anyway for me. Your Honor, the state's going over the paperwork on the agreement, and I will be approaching with the score sheet.
Mr. Medina.
Oh, thank you. Yeah, too.
Thank you. And the defense is in agreement on the score sheet?
Yes, Your Honor.
Okay.
And I have it on my phone. I just need to get the right one. Your Honor, under the terms of the agreement, Mr. Averett will be changing his plea from no contest to from not guilty to no contest in exchange for the following: withhold of adjudication as charged, 24 months probation on count 1, 11 months 29 days concurrent probation on count 2, 515 court costs, 150 public defender fees, 24 hours community service, no trespass at Dan's Pawn Shop, anti-theft class, maintain gainful employment or complete 2 applications per week, no firearms during supervision, random UAs at least once a month.
Mr. Abbott, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney, you can put your hand in. You heard your attorney state the terms of your plea agreement,
Yes, sir.
and those terms are contained in writing in your written plea agreement that you've signed.
Yes, sir.
Have you read this thing closely?
Yes, sir.
Have you gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Importantly, you know that you're waiving some valuable legal rights by entering into this, the right to go to a trial and to fight this thing.
Yes, sir.
You believe it's in your best interest to waive those rights in order to enter into this plea agreement?
Yes, sir.
And have you had all your legal questions answered by your attorney?
Yes, sir.
You satisfied with your legal representation?
Yes, sir.
Okay, very good. Based upon that testimony, the court will accept the plea agreement. There'll be a withhold of adjudication as charged. And as to count 1, you'll be sentenced to 24 months probation. As to count 2, you'll be sentenced to 29 months concurrent probation, so they'll run at the same time, so a total of 2 months. And that's as to count 2, the 1129. You've got fees and costs, and you've got 24 hours community service, no trespass at Dan's Pawn Shop, that's important, anti-theft class, no firearms, and the other things, details that are contained in the plea agreement. Any questions?
No, sir.
Okay, thank you very much.
Thank you.
Your Honor, Steve Medina with Trayvon Q. Blunt, 20 CF 1879 and 22 CF 2355. When Mr. Blunt was here on pretrial day, we agreed he would come back on docket day for plea at trial. I've gone over the situation again this morning with Mr. Blunt, and he does want to go to trial. I do need to put on the record that I communicated between pretrial and today with Ms. Basso. The state was willing to agree to a deal that would have avoided the sex offender designation. It would have involved 8 years prison followed by 10 years probation. Mr. Blunt, against my recommendation, does not want to do that deal. I don't think that there's any need for further discussion. We will be returning on jury review and expect to go to trial this cycle, Your Honor.
Your Honor, state's prepared to proceed and all offers of the vote.
All right, so you understand that, sir, offers are off the table following today?
Yes, sir.
Okay. And how long of a trial do we anticipate?
Exclusive jury selection day, maybe?
Exclusive, so
I think 2
we
days.
start and go a couple days. Okay.
That should be adequate, Your Honor.
Okay. So we'll come back and we'll get the exact time, when we schedule it. When we come back on Thursday, we'll get our time slot and everything. We got at least one other trial, looks like it's going.
Thank you, Your Honor.
Okay.
Your Honor, Malik L. Cooper is docket 82. Cases 22 CF 212, 23 CF 553. When Mr. Cooper was here last week on Wednesday, we agreed he would come back today for basically a status on the situation. I do want the court to know that I reached out to my investigators. As of now, she hasn't been able to find a place that would provide him housing were the court to consider some sort of signature bond. I can't represent to the court that he's going to have a place to go based on the limited information. Based on my observations when he was before the court last week, I do feel compelled as an officer of the court, even though I want to help him get out of jail, I don't want to knowingly be part of anything that might be questionable as to whether he was competent to do a probation deal. So I think at this point in time, the public defender's office had contracted for a confidential evaluation, was ultimately filed by Dr. Zeman saying he was not competent. The court appointed a second evaluator who said he was competent. So I think at this point in time, I need to ask for a third competency evaluator by Dr. Randy McDonald, who's not, to my knowledge, one previously looked at him, and see what she has to say as to whether he's competent. But I also am being very forthright as to the situation with the court. I wish he could take a deal to get out on probation. I think the nature of the charges are such that you really shouldn't be in jail. But that's the situation, Judge.
State okay with the third competency eval?
Absolutely, Judge. The state was going to suggest that, and Mr. Mahoney did not. So absolutely, I think it's necessary.
And I will, with the court's permission, be submitting the standard order of appointment, and it'll include Dr. Randy McDonald's. I don't think we have to have a specific hearing on that if the court is in agreement with it, unless the court directs otherwise, and we could just put him on December 13th for a control date.
Sure. That'd be fine. We had this discussion a little bit last time, but is the mental health diversion program a possibility? Has that been looked at least?
My understanding was it was not going to be available. I can't remember at this time, but I did reach out to the pretrial services officer whose name escaped. It's Cindy, I believe. It's Cindy Myers, I believe. And I believe she told me that it was not a viable option. Ms. Sharpless handles mental health. Do you think there's...
Well, it's a little different. The diversion program isn't exactly, it's not mental health court. The diversion program.
I would have to speak to Ms. Myers, Your Honor, in reference what would keep him. I know that it's not just Ms. Myers who approves candidates for the 90-day program. So I could ask Ms. Myers what the issue was.
I think it might have been basically a concern about the degree of competence or the degree of his situation in terms of his ability to comply with those conditions of that program. But if the state, would you mind reaching out to Ms. Myers to see if that might be...
I'll ask Ms. Myers, Your Honor.
That was my original hope, Your Honor, a long time ago.
Yeah, I mean, I understand we can't force, nor do we want to force any type of a plea agreement based on competency, but I'll just say that I have some concern that he's even in jail. And just because he's not competent to hold somebody in jail, I have some issues with that. But apparently
I don't think that's the reason that he's in.
Well,
His competency evaluation.
Well, I know it's not because of the competency evaluation, but anyway, I don't know, there's a lot we can do about it, but.
And Your Honor, I will also continue to talk to my investigator who has better information than I have. I also mentioned maybe Bridgeway, their regular housing type program. You know, I have always felt he needed some help. But the doctor for the Agency for Persons with Disability said, you know, said what he said, so.
Okay. Okay, well, we'll proceed forward with it then.
Thank you, Your Honor.
Thank you.
Take care, sir.
Jason Colhart.
Your Honor, Mr. Jason Colhart is here. He's docket number 83.
Afternoon, Your Honor.
Good afternoon.
Oh, I'm sorry, for Mr. Cooper, could we have a 1213?
It was 12:13. It's all right.
And I'll be submitting the order, Your Honor.
Sure.
Your Honor, Mr. Coldheart is docket 83. I will not repeat the case numbers for Jason Christopher Coldheart, if that's okay. Your Honor, we were here, basically, this is a docket day for plea or continue, but in essence, we were here for a status check because the state was going to check with Niceville Police Department on the status of production of the video. That was important for us to be ready for trial.
So where are we at with that?
Your Honor, give me just a second, because I did it last week.
And while they're doing it, I'll go, we need to put the case numbers on there.
Okay, yes, Your Honor.
I'll do it.
Okay.
19 CF 2339, 20 CF 298, 20 CF 299, 20 CF 341, 20 CF 588, 22 CF 3184.
Thank you, Your Honor.
I do know that I did get an email from the evidence.com responsible person at Niceville Police Department that said that the videos that he was requesting have been added to the case. I don't have information right this second whether they've been reshared with Mr. Medina, but if you'll allow me, I will make sure that gets done before the end of court today. I don't hold court.
That is it, more or less what I anticipated, because when we took the depositions, which was fairly recently, the person that does this was not in that week, and so they were going to be the following week, which was, I think, last week or the week before was the week when they were going to work on it. So here we are.
So are we ready to go to trial?
No, Your Honor, we need to continue to December 13th so I can look at the video. I need to be able to go over it with him. That it would be a last continuance.
Okay. This is a real last. 12:13. Continue till 12:13.
And I would ask the state, if you'll confirm that you'll be ready to give us an amended discovery exhibit, cross-referencing that. I guess I just want to make sure that's part of the record real soon, because if the court is justified in saying a last continuance, I need to get a hold of this
You need to
stuff.
get your stuff.
Yeah.
Yeah, I understand that. You need to you need to be able to review this. She said counsel said she was going to get it to you by the end of business today. Right?
Yes, sir. Okay, thank you, ma'am. Thank you.
Thank you. Thank you, Your Honor.
Thank you.
Thank you, sir. Your Honor, Joshua James Cruz is approaching in docket 84, 23 CF 1541.
Before we proceed,
No. Sorry, sir.
with Joshua James Cruz,
Hold on.
I used,
Oh, wait. Hold on.
I'm sorry. I want to raise my right to the I'm reading. Your Honor, may I please, with all due respect, Dr. James Cruz, affirming waive my right to faithfully plead out to Judge State, please. May I?
To do what?
plea out directly to the judge.
Oh, you want a plea?
Yes,
Your
sir.
Honor, if he,
Please and thank you.
I am highly recommended that he do an open plea. I think if he was going to do a plea to the bench, that I might be able to negotiate a cap on DOC. And so I think it would be against his interest. But if he wants to do it, he may want to also relieve the public defender.
Your Honor,
Yeah.
before
Hold
we
on.
proceed,
Raise your right hand.
yes, sir, thank you.
Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, Judge Ketchum.
Before you do that, would counsel approach?
Yes, Your Honor.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
So, Mr. Cruz, you're under oath.
Cyclone Bakery Cafe.
And tell me again what you're requesting. You're requesting that to enter into a plea agreement, to basically do a plea to the bench, essentially. Is that what you're asking?
Yes, sir. I know my limits and I know my charge. I've been, unfortunately, if it wasn't for the correctional facility, I'd probably be a lot worse than I am. So I do hold myself to that.
What is the, what's the maximum, go over to that mic so I can hear
Yes,
you.
sir.
Well, what's the maximum sentence that Mr. Cruz is
Yes, sir.
exposed to? He's got a felony,
Petty theft.
felony though.
Yes, sir.
Your Honor, Mr. Cruz is currently charged with third degree level 1 petty theft. The maximum on that charge is 5 years permanent correction.
A max of 5 years. Do you know that's the maximum sentence? Do you know that?
Yes, sir.
Okay. So you ready to roll the dice? See what,
Judge
do
Ketchum.
you want your attorney to assist you, to help you argue? If I allow the trial, the plea to the bench, I'm not going to sentence you today, you understand that? All we're doing today, if anything, is to accept a plea. I'm not going to sentence you today, because the state has the right to prepare for it, and you want to prepare your defense too, to try and, get as low of a sentence as possible. You don't want to just,
I was hopefully thinking that I was rolling the dice and I was going to get a sentence to whatever Judge Ketchum tells me today, and I didn't have
that's
to.
not, I'm not going to do it that way, because I'm just going to tell you, I'm not going to do a half-assed sentence and put you down, send you to DOC or something without giving you a chance to defend yourself and giving the state the chance to argue what they believe in. This is important stuff. It's not something you can rush. I'm not going to do it.
Yes, sir, Judge.
So I will accept, if you want to do a plea to the bench and roll the dice, that's fine, but it ain't going to happen today.
Well,
So,
may I just wait and apologize for the disturbance, and can I just take the offer on the table, which is 24 months probation? Please.
Is there something on the table?
Yes.
Hold on.
Yes, sir.
Is there a plea on the table?
Yes, sir. It's
2
20
years drug offender probation, Your Honor.
A what?
2 years of drug offender probation was the state's plea offer.
Now, are you now saying that's what you want to take?
I was hopefully getting sentenced today with Judge Ketchum, but I believe that I can.
If you, I'm not trying to get you to do it, but if you would enter into a plea today for 24 months of probation, then it'd be done, you'd be sentenced.
Be sentenced.
You'd get that done today.
Yes, sir.
Is that what you want to do?
Thank you, Judge Ketchum.
Is that what you want to do?
Yes, sir.
Your Honor, I believe he has that, do you have that paperwork? I
don't
sent it back to you.
We need to go ahead and you need to hang around just a little bit. We need to get the paperwork, and we'll bring you back out.
Thank you, Judge
Okay?
Ketchum.
And look for it back there. Is it possible you still have it back there?
I'll see you get it out.
Well, we can get that
We'll get
revised
it.
very quickly, Your Honor.
Okay,
Thank you. I'd written it up by hand and.
That's all right.
Something else and, typed. Corey Culver.
Excuse me,
Your Honor, at this time, we need to continue Mr. Culver's case. The state's offer is 12-1. When I spoke to the state last week, it was very clear that it would not do probation. I do not know if the defendant wanted to be evaluated for Keaton. I think that's certainly a possibility, but I know he doesn't want to take 12-1, and we're not going to get the case resolved today.
May I ask a question?
Your Honor, basically, he's pointing out that the score is, he's not scoring DOC. His score would be, if the charges stick, 33.6, according to
okay,
the
so,
state's offer.
Mr. Culver,
Yes, sir.
the way it works, and I know your attorneys probably shared this with you, but I'll just say it again, just law. I'm not giving you any advice, or I'm just telling you the straight up law. A lot of people confuse this. They look at the minimum guidelines and they say, well, that's what the state is going to offer me. And a lot of times they do. But they're under no obligation to offer minimum guidelines. As a matter of fact, if you were convicted, the state could argue for, much higher than that. So the minimum guidelines are not the determining factor. There are other things that go into it. And I'm not saying, I don't know what they are, and I don't need to know that, but I'm just, you're confusing a little bit the minimum guidelines with.
Yes, sir. Well, I just wanted to say,
Your Honor.
I'll go ahead and sign up for a while. I just want to do my time and get over it and get back to being a better man. So I'll just go ahead and sign it.
Your Honor, he's indicating he'd like to take the state's 12-1.
Does it come with the credit for the?
Yes, you'll get credit for time served.
I'll sign it.
I'll write it up. Your Honor, could he be sent back briefly, and I'll
Sure.
write it up as soon as I can on a break? It shouldn't take very long. Okay.
We'll get it done today.
I just want to. Thanks.
I think that's your last one, isn't it?
No, Your Honor. William Dorsey. Your Honor, William Brian Dorsey before the court, 23 CF 1458, docket 88.
Yep, got it.
When he was in the court last week, I mentioned, I believe, that I had asked the state to consider a non-incarcerative option.
Yes.
And I don't know if the state has been able to make a decision on that. Your Honor, at this time, I think we need to continue to next cycle, and I will see if there are any depositions that are needed, and we'll prepare for trial next cycle.
Okay. State?
I'm losing my
Can the state indicate what its offer would be if he were to take it off the plea today? I just want to make that clear because he's indicating he wants to resolve it today. My understanding was the state's offer was a guidelines offer, and that was 33 months, and I don't think he wants to take that. This is, yeah.
Yes. Judge, the state's offer is a guidelines prison sentence.
Which is?
33 months.
Your Honor, it's possible that we'll be able to reach a resolution and accelerate things, but at this point in time, I think we need to continue to December 13th.
Okay. We'll continue to December 13th.
Michael Evans? Your Honor, Mr. Evans has an agreement in his hand. I need to open it up and discuss it with him, if I may, for a moment.
Sure.
May I inquire of one thing with the state, Your Honor? Mr. Evans, if he were to take the offer that you and I discussed, it would be a bars to bed Phoenix house, and the state has agreed that it would be 3 years probation with a right to seek early termination at the 2-year point. He's asking, is it possible he could get a short furlough to get his affairs in order? Could we put in a short furlough as part of the agreement?
Mr. Rager, I can't agree to any furloughs.
Excuse me.
Okay.
When I speak to
I can't override the agreement. Either they make an agreement or they
I only
don't.
want to ask a question. Okay.
Your Honor, if he wants to relieve the public defender, otherwise I'm advising him not to be discussing his case with the court directly.
I don't want to ask a question, Your Honor.
You can ask a question.
How you doing today?
Raise your right. Raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the true self you got.
Yes, sir.
You know we're being recorded?
Yes, sir.
Okay, go
How you
ahead.
doing today, son?
I'm doing fine. How are you doing?
Well, I say why I asked for a furlough. I ain't saying like until the key to the Phoenix house come get me, because I want to go to the Phoenix house.
Mr. Evans, let me say it again. You didn't hear me. I'm not trying to be harsh here, but I'm telling you. If you make an agreement, the agreement is between the state and you, not me.
Can I
In
speak?
other words, they're saying no, and you want something. I can't get in the middle of it.
I know.
So even if I agree with you 100%, and I don't have a dog in the fight.
But
Okay? I know you think I can.
I
Now,
know,
you're the
I know,
judge,
yes,
you can
sir.
do what you
Yes,
want,
sir.
but I can't.
yes, sir. But
Okay.
it's just that I don't want to wait the whole time to go to Phoenix. I want to go there quick as possible. But
Okay.
I got stuff at my baby mother's house, like my belongings, like clothes, my bed and stuff. I just need time. I talked to my baby mother. She said she'll pay for the storage unit to hold my stuff till I get out. But she ain't in a condition to move it. She ain't strong enough. She just coming off of corona. She can't come out the house. She said I can move the stuff to the storage unit. She'll pay for the storage unit. So I just need like maybe 48 hours, 72 hours, or like that, just to move the stuff into the storage unit. And I'll turn myself back in. I ain't never been a fight risk. I've been going to court like going on 2.5 years. I haven't missed now court date. I never had a failure to appear a day in my life. It's just
Mr.
that
Evans,
I
I
just
don't have
need time to move
authority
it.
to do what you want me to do.
Yeah, I ain't never had a failure to appear. I never had a I went to every court. I've been going to court since 2021 for this case here. I never missed a court date. I don't even walk here before. I stay right in that 4-1. I just want time just to. She was able. She had to be home for 14 days because she got corona. She can't leave out the house. They got on some kind of quarantine. I just want to move my stuff out of there, put it in an American storage unit. I can even be escorted by a deputy. And then I can go back to the jail. It don't matter. I just want the time just to move my stuff out of her house into a storage unit so when I get out, I at least have some of my belongings. She said she'll pay for it all. but she just can't leave out the house because she's on quarantine for 14 days.
Your Honor, the state does this, Mr. Evans, the state has to do it for every other defendant, and I can't agree to refer it.
Okay, thank you.
John, you Your Honor, he's been over the agreement, he understands it, and he wants to go ahead and take it.
Okay.
May I just, I've added a provision that was in his favor. I want to make sure he understands it.
I don't do it because I have a truck that's full. Yeah, I understand.
Your Honor, Mr. Evans is going to go ahead and sign this agreement. I apologize, we don't have an extra copy for probation. The state's already signed it. That's where you sign if you want to do it.
You want to go ahead and announce the agreement?
Yes, Your Honor, may I do need a score sheet. I'm going to make sure I have a copy, Your Honor. I think I do. I just want to make sure I haven't written on it. Your Honor, I had kind of circled in a couple places, but I haven't changed the information. Under the score of the state, the score sheet for Mr. Oh, excuse me, this is the wrong. I apologize, Judge. I pulled the wrong, I had the wrong file out here. All right, just give me, I'm doing my best.
Okay, we expect.
Just a minute. May I have your indulgence, Your Honor? I didn't have.
That's all right.
That's right. Your Honor, I'm showing him the handwritten score sheet that we had received roughly a year ago with 28.8 points, so he was at scoring prison.
So that's not prison time right there? Score up there?
You're not. Your Honor, may I inquire the state, if the state was doing a straight incarceration, what would the state's offer be? If the state, you know...
I can't possibly answer that question right this second. I don't have anything.
That wasn't an option that we advanced prior to today, Your Honor, but I'm raising it so he could consider it.
If
you don't... Is the state's saying it's not prepared to give him a straight incarceration?
It's not saying they won't. They're just saying that this is sprung on them, and it takes time for them to develop their.
So we don't have an answer to, you know, for you to consider.
All
right.
Okay.
Your Honor, it's been signed by all parties I'm approaching, and it is 28.8 points on the score sheet. You see that?
I see it.
Yeah, okay. May I approach, Judge?
You may.
I'm sorry, Your Honor. I made that change, and I wanted to make sure I had it.
Thank you.
Your Honor, under the terms of the agreement, Mr. Michael B. Evans, Jr. will be changing his plea from not guilty to no contest. Under the agreement, there would be an adjudication of guilt as charged. There would be 3 years concurrent probation, and there's an asterisk that he may seek early termination after 2 years if he fully complies. There will be a special condition of bars to bed Phoenix House. reserve jurisdictional restitution for 180 days, no trespass at Tom Thumb or Cumberland Farms, anti-theft class, maintain gainful employment or complete 2 applications per week, 515 court costs, 150 PD fees, and Mr. Evans has mentioned to me, and I've advised him, I'm putting on the record that I had no basis for a motion to dismiss, simply based on the fact that Cumberland Farms took over the corporate entity of Tom Thumb. That was not going to be a valid legal defense that I was going to, and I was not going to pursue that theory of his. Thank you.
State in agreement.
Yes, Your Honor, that is the same.
Mr. Evans, would you raise your right hand? Well, you're already under. I already put you under. So you heard your attorney state the terms of your plea agreement?
Mm-hmm. Yes, sir.
Yes? And I see you've signed the plea agreement. Are you all, is the defense in agreement onto the score sheet?
Yes, Your Honor.
Okay. So you heard your attorney state the terms, and they're contained in writing in your written plea agreement that you've signed. Have you read this closely? It looks like you have. Have you read the plea agreement closely?
Yes, sir.
And have you made sure to talk with your attorney in detail about the plea agreement and made sure you had all your legal questions answered?
Yes, sir.
Okay. You understand?
Not all my questions answered, but for the most part.
Well, is there another legal question that you have that you need to add? If you have some legal questions, I know there's some things that you don't like about this. That's different. When I'm asking you, I want to make sure you're doing this with knowledge. Nobody's trying to trick you. Nobody's trying to twist your arm. Whether it's with knowledge and free and voluntary. That's the purpose of my questions. So, have you had all your legal questions answered to make sure that you understand what this agreement is all about?
Yes, sir.
Yes? And you understand that by entering into this, you're waiving the right to go to a trial. You can contest all this.
Yeah, that's why I can add. It ain't no way, let's say like 5 months from now, I can't come back and retry this.
No, this will be a final adjudication of the claims.
Oh,
Now,
so I
you
can
do have,
appeal this
listen to me, you do have the right to appeal this.
in the future.
You've got 30 days to appeal it. And, you know, there may be some other, that's why I'm asking you these
Okay.
questions.
That's all
Your
right, that's all
Honor,
right.
may I interrupt, Your Honor?
Sure.
I just wanted to make it clear on the record that under the terms of the agreement, just because the court is saying you do have 30 days to appeal doesn't mean it would be a valid appeal. Under the terms of the agreement, absent of substantial change in circumstances, you really can't appeal it or seek modification of it in any way that's going to have any hope of success.
Even if it's
That is
over
correct.
now.
So what he was saying, I actually was going to say the same thing. So when you enter into this plea agreement, as long as you do so knowingly, and you're telling me you do, you've had all your questions answered, you've read this, if you enter into it knowingly and freely and voluntarily, you can't just change your mind in a couple months. That won't be. You can file an appeal. That won't get you anywhere. But, this will limit your ability. You do have the right to appeal. It has to be done within 30 days. You understand that? But by entering this plea agreement, you've signed this thing already. By entering, if I accept this, you will greatly limit your ability to appeal this. You understand that? I can't give you every detail because I don't know what's in your mind about why to appeal it. But it does greatly limit your ability to appeal. Do you understand that?
Yes, sir.
Do you still want to enter into this agreement?
Yeah. Yes, sir.
You sure?
Yes, sir.
Okay. I'll accept the plea agreement, and there'll be an adjudication of guilt as charged. You'll be sentenced to 3 years concurrent probation on each of the charges with a special condition of bars to bed, Phoenix House program. reserve jurisdiction on restitution for 180 days. No trespass at the Tom Thumb or Cumberland Farms stores. And a theft class, maintain gainful employment or make 2 applications, and you've got fees and costs. You may seek early termination after 2 years if you're in full compliance.
Your Honor, Mr. Evans is continuing to kind of voice the fact that he says he's never been in Cumberland Farms, and this is that point I raised.
I understand that.
Thank you.
Wait a second, Mr. Evans. Mr. Ewing, will be next.
Senator Steve Medina with John Jacob Ewing, docket 92, 22 CF 2460. I anticipate providing to the state, after I can properly evaluate it, some names of 1 or more persons who might be called as witnesses, but I have to evaluate that with my client. I will see him as soon as possible about that, and I would ask to continue this case for a last continuance to December 13th, Your Honor.
That's without objection. Mr. Ewing did mention something about that to Mr. Medina at the pre-trial, so we were aware of that, and certainly we have any witnesses. We believe it's appropriate to discuss this.
Your Honor, he's given me a counter proposal. May I have just a moment with Ms. Basso to tell her something?
Sure.
Thank you.
What's his name?
So, Your Honor, he's given me an idea that I pass on Ms. Basso. The state's not prepared to accept it at this time, but if we can work something out by next cycle, that's in his.
If you can work something out before the next cycle,
Right.
we will definitely put it on a miscellaneous docket and get you squared away on any kind of plea.
I believe the state's offer was, it was 10, I believe. I apologize. I think it was 10 with with no sex offender designation followed by.
I haven't been involved with it at all.
I'm sorry.
Yeah, and we're not going through that right now, Mr. Medina. I don't have it handy because I wasn't anticipating having any of these discussions. Mr. Ewing had affirmatively rejected it.
I mean, if you get something worked out, we can get it back on the docket quickly.
Thank you. Thank you, Your Honor. And I had a couple where I was writing things up, Your Honor.
Well, I write this up, Your Honor. I have Mr. Cox in the gallery. He said that he was on the docket for today. I haven't scratched that. We don't have done it. His name is Jeremy Ray Cox.
Yes, that is, I think that's the one with, hold on a second. What number is it, Madam Clerk?
Well, it was under Mr. Stevens.
It was Stevens, that's right, right. I remember. No, we had Mr. Notes. So your name is, you're Jeremy Cox? Okay. Mr. Cox, you were here today on a PTI recall. You're actually here a couple weeks ago, and we tried to get this. So fortunately, you have, we finally caught up with you. You have been appointed conflict counsel. And I actually informed Mr. Nopes, Marty Nopes. Okay? Have you been given that name?
Yes, sir.
Okay, you need to call Mr. Nopes and set up an appointment. I'm going to go ahead and schedule this for 12/11, unless December 11th, for the next hearing, okay? But in the meantime, meet up with Mr. Nopes, Knopes. Marty Nopes, he's up in Crestview. He does a lot of work down here as well, but you'll call his office, make an appointment, and he'll help. You got to figure out where you're going. Okay?
Thank you, sir.
Thank you. Okay, so we will take a short recess, wait for, complete these. When you get the two plea agreements ready,
He's almost done, I think. You're almost done, aren't you?
Mr. Cole will need to read his, so maybe 10
I'll take a
minutes.
10 minutes, that's fine. Mr. Rogers, when are you leaving?
I've got a month left, Judge.
Okay,
Thanks, Your Honor.
thank you. Not happy enough.
I know, but I just wanted to stop by and see you and Judge Brown before
Sure,
I leave.
yeah, I
I'm
know.
gonna slip out the back door.
Yeah, just run out.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit.